Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Aarti Highrise Private Limited versus the Joint Commissioner of Income Tax, pronounced by Calcutta High Court on the 21st of May 2026. The petitioners, Aarti Highrise Private Limited and Abhilasha Heights Private Limited, challenged a show cause notice dated the 25th of November 2025 under Section 148A(b) of the Income Tax Act, 1961, for assessment year 2015-16. Subsequently, an order under Section 148A(d) and a notice under Section 148 were issued on the 29th of January 2026. The core issue was whether the reassessment notices for assessment year 2015-16, issued after the amendment to Section 149 effective from the 1st of September 2024, were time-barred under the amended limitation period of 3 years. Under the amended Section 149(1)(a), a notice under Section 148 cannot be issued if 3 years have elapsed from the end of the relevant assessment year, unless the case falls under Section 149(1)(b), which requires that income escaping assessment amounts to or is likely to amount to Rs 50 lakh or more. For assessment year 2015-16, the 3-year period ended on the 31st of March 2019. The petitioners contended that the extended 10-year period under Section 149(1)(b) was not attracted, as there was no allegation or material to show that the escaped income met the threshold of Rs 50 lakh. The respondents argued that a survey conducted on the 27th of March 2024 prior to the amendment justified the reassessment. They claimed that the pre-amended provision of Section 149, which allowed notices within 6 years, or 10 years in certain cases, should apply. The court's reasoning was anchored in the Supreme Court's judgment in Sai Kumar Mateti, which clarified that after the amendment effective from the 1st of September 2024, all reassessment proceedings must comply with the amended Section 149. The Calcutta High Court applied this principle directly. It observed that the impugned notice under Section 148 for assessment year 2015-16 was issued beyond 3 years from the end of the relevant assessment year, 31 St. March 2019. Since the notice was issued in November 2025 and January 2026, it fell outside the limitation period prescribed under Section 149(1)(a). The court further noted that the respondents did not produce any material to show that the income escaping assessment amounted to Rs 50 lakh or more, which is the sole condition for invoking the extended 10-year period under Section 149(1)(b). Without such evidence, the notice was without jurisdiction. The court rejected the respondents' argument that the pre-amendment provision should apply because the survey was conducted before the 1st of September 2024. It held that the amendment was procedural and retrospective in effect for all notices issued after its enforcement. The court emphasized that the time limit for issuance of notice under the unamended Section 149(1)(b) ended on the 31st of March 2022, 6 years from the end of assessment year 2015-16. Since the notices were issued in 2025-26, they were also barred under the old law. The court also addressed the procedural validity of the Section 148A proceedings. It noted that the show cause notice under Section 148A(b) and the order under Section 148A(d) were consequential to the invalid Section 148 notice. Since the foundational notice was time-barred, the entire reassessment process was quashed. The court disposed of the writ petitions by setting aside the show cause notice dated the 25th of November 2025, the order dated the 29th of January 2026 under Section 148A(d), and the notice under Section 148 of the same date. Question: what was the key legal issue in this case? Answer: the key issue was whether reassessment notices for assessment year 2015 to 16, issued after the amendment to Section 149 effective from 1 September 2024, were time-barred under the amended limitation period of 3 years. Question: why did the court quash the reassessment proceedings? Answer: the court quashed the proceedings because the notice under Section 148 was issued beyond 3 years from the end of assessment year 2015 to 16, 31 March 2019, and the revenue failed to provide material showing that the escaped income was Rs 50 lakh or more, as required under Section 149(1)(b). Question: how did the Supreme Court's judgment in Sai Kumar Mateti influence this case? Answer: the Supreme Court in Sai Kumar Mateti held that all reassessment notices issued after the 1st of September 2024 must comply with the amended Section 149. For assessment year 2015 to 16, such notices are time-barred unless the conditions under Section 149(1)(b) are satisfied. The Calcutta High Court applied this binding precedent. Question: did the survey conducted before the amendment affect the limitation period? Answer: no. The court rejected the argument that the survey date, 27th March 2024, justified applying the pre-amended law. The amendment was procedural and applied to all notices issued after its effective date. Question: what is the significance of the Rs 50 lakh threshold under Section 149(1)(b)? Answer: the threshold is a condition for invoking the extended 10-year limitation period. Without evidence that the escaped income meets or exceeds this amount, the revenue cannot issue a notice beyond 3 years from the end of the relevant assessment year. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, taxpundit.org. If you have any questions, feel free to write to us at taxpundit@taxpundit.org, or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.